Dear students, aspirants, viewers and the subscribers, welcome to the IAS Mentor. We are continuing our series on Indian polity, and this would be our lecture number 51. As I already said that we have crossed a milestone in this series. We have covered the philosophical part of the constitution. We have covered right from the historical background until what is called as the basic structure of the constitution. And in the process, we have covered the fundamental rights, duties, DPSP. We have covered citizenship, union and its territories, preamble, the Constituent Assembly. All these topics have been covered. So these are all very important for the examination. You can expect 4 to 5 questions minimum from these areas. I'm on a very conservative note, I'm saying it. So, but now we are entering into another phase of the Indian polity. Of course, whatever we are going to see from now on, it's more interesting. Because whatever is the first part, that is more philosophical in nature, but now as we will proceed, we will be able to correlate with a number of things that we see on a daily basis. And the next part that you are going to discuss right now is the executives. And in the executive, if you see, there are 2 types of executives under the constitution. One is the union executive, and then that is the state executives. So who are basically executives and who are union executives, who are state executives? We'll try to understand all those things. But first, what we will start with is we'll start with what is called as the union executives. We have already seen the concept of what is called as separation of powers. Now, in the concept of separation of powers, the constitution provides for 3 organs of this: the legislature, the executive, and the judiciary. So one of the organ of the state is what is the executive, and that executive is further divided into what is called as union executive and state executive. So today in this lecture, we are going to start with union executive. We will not be able to complete it. We will go on for another at least 7 to 8 lectures before we will have some ground on what is called as union executive. And in the union executive, who are all part of it as per the constitution of India, the union executive consists of the president of India, the vice president of India, the union council of ministers, including the prime minister, and then in addition to that, we will also see what is called as the attorney general of India, and we will also see what is called as the comptroller and auditor. So although they are not considered to be part of the union executive, I will not cover the CAG here, but I will try to cover all the other things. That is the President of India, the Vice President, and then of course I will also cover what is called as the Union Council of Ministers, and then I will also cover what is called as the Attorney General. CAG I will do it separately when I take up the constitutional process. These are all the things that I am going to cover under the Union Executive. So similarly, we have the State Executive also, but I will do that at a later stage once I complete what is called as the Union. So with that, we will take up the first authority under the union executive. We will also consider the head of the union executive. Idea about before I go into the discussion on the president, I just wanted to know as to what is your understanding of what is the constitutional position of the president in our country, or what position has been envisaged by the constitution of the president of India. So in other words, is he a real executive? Is he a nominal executive? So we'll have to first understand this particular question before we proceed with any of the other constitutional provisions relating to the president of India. So what is the constitutional position of the president of India? That is one of the 4 most important questions that we have to understand. Now, if you look into the constitution, there are few important articles that you'll have to understand before we answer this particular question. Article 51 of the constitution says that there shall be a president. And that means the country cannot function without a president. There shall always be a president. And then Article 52 of the Constitution, small correction, sorry. Article 51 is the fundamental duties and DPSP. So Article 51 is related to the directive principles of state policy. It is only Article 51A is related to the fundamental duties. So Article 52 is saying that there shall be a president. Article 53 is saying that the president is the head of the union executive. Who is president? The president is head of the union executive. Or other words, of all the executives at the union level, who is the head of all those union executives? It is the president who is the head of the union executive. So by understanding Article 52 and Article 53, now tell me what is the position of the president. Is the president, when I talk of this constitutional position, I just want to know whether he is a real executive. When I say real executive, that he has the real executive powers. He has all the executive powers, he can decide on his own, or he is just a nominal executive. When I say nominal executive, he may not have all the real powers, but for namesake, he is the union head of the union executive, but the real powers may rest upon some of the other people or some of the other authorities. That is basically what is called as nominal. Nominal means for namesake. Although under the constitution he is the head, but he is not the real authority. That is nominal executive. He is the real executive. In the constitution also he is the executive. Practically also he is exercising all the powers. So that's basically what is called as the real executive. So if you just read Article 52 and Article 53, which says that there shall always be a president and the executive powers shall be vested upon the president, it appears that the president is the real executive. But in reality, that is not the case. In reality, the president is not the real executive. The president is merely a nominal executive. So that is what was envisaged in the constitution itself. To understand that, we should also understand what is called as Article 74 of the Constitution. So if you read Article 74 of the Constitution along with Article 52 and Article 53, it makes it very clear that the president, though he is the head of the union executive, the president shall act in accordance with the aid and advice of the Council of Ministers. That means the president cannot act on his own, but rather he has to act in accordance with what is called as the aid and advice of the Union Council of Ministers, which is headed by the Prime Minister. That means the Constitution is saying the president is a head, but this head cannot act on his own. He can act in accordance with the aid and advice which is given by the Council of Ministers, which is headed by the Prime Minister. That means whatever the Prime Minister and the other ministers advise the President is bound to do that. In fact, the question arose that whether the aid and advice that is given by the Council of Ministers is it binding upon the President. Because what happened after the commencement of the Constitution, some of the presidents started not listening to the advice. So for example, Dr. Rajendra Prasad was the first president of India. In certain instances, he was not listening to the advice given by the council. That is the Council of Ministers. And there is nothing explicitly in the Constitution, in the original Constitution that I am talking about, to say that the aid and advice is binding upon the president. So this matter was taken up by the court, and the Supreme Court, in the Samstation case, has made it very clear in 1974 that if you see the kind of parliamentary system in India, the parliamentary system is similar to that of the parliamentary system in Japan. Though it is not explicitly mentioned in the Constitution that the aid and advice is given by the president is binding upon the president, but our parliamentary system is modeled on the lines of parliamentary system of United Kingdom, where in the parliamentary system of United Kingdom, the advice that is given by the Council of Ministers there is binding upon the monarch. That is binding upon the king or queen, whoever is a monarch. The only difference here is that instead of monarch, we have an elected president because we are a republic. And in a republic, the head of the state is always elected. So here also, the aid and advice which is given by the Council of Ministers should be binding upon the president. So the president cannot act on his own, but rather of the aid and advice of the Council. So the matter was settled by the court in 1974 in a case which is called as the Samstation case. But what was settled by the court was again explicitly put into the Constitution by way of the Constitutional Amendment, that is the 42nd Constitutional Amendment Act 1976. The 42nd Constitutional Amendment Act 1976 was made when when the Prime Minister of India was Indira Gandhi. So when Mrs. Indira Gandhi was of India, So at that point of time, a constitutional amendment was made, and through that constitutional amendment, it was categorically made clear that whatever is the aid and advice that is given by the Council of Ministers is binding upon the President. So to that extent, they have made changes in the Article 74 of the Constitution that the President shall act in accordance with the aid and advice of the Council of Ministers. So what was held by the Supreme Court in 1974 in the Shamsher Singh case was explicitly brought into the Constitution. And today, if you see, as per this amendment, that the President shall act in accordance with the aid and advice of the Council of Ministers, which means constitutional terms that the aid and advice which is given by the Council of Ministers is binding upon the President. So it is only reiterating what has been held by the Supreme Court, that the President is more or less a nominal executive. He is not a real executive. Whereas the real executive is the Prime Minister and the Council of Ministers, on whose advice the President has to act. But however, our understanding will not be clear without understanding what is called as 44th Constitutional Amendment Act 1978. After the 42nd Constitutional Amendment, one more amendment has also been brought in. What is that? That is the 44th Constitutional Amendment Act. If you see this 44th Constitutional Amendment Act, this 44th Constitutional Amendment Act amended Article 74 of the Constitution, which says that while the aid and advice which is given by the Council of Ministers is binding upon the President, no doubt, it is binding upon the President. But if the President is not happy with any of the advice, or if the President is having reservation with regard to any of the advice, then the President can refer this matter once to the Council of Ministers. He can send it once to the Council of Ministers, and if the Council of Ministers again send it back, then again send the advice back to the President, then it is binding upon the President. Otherwise, it is not binding upon the President. So this is exactly what you'll have to understand. So try to understand that in case of the constitutional portion, you will have to look into what is called as both the 42nd and the 44th Constitutional Amendment Act. While the 44th Constitutional Amendment Act makes it binding upon the President, that is the aid and advice binding upon the President. But however, if the advice is sent back, or if the President is not happy with the advice, and if he is sending it once for the reconsideration, that means he can send it once for the reconsideration of the Council of Ministers. But however, if the advice is again sent back, then the President has to accept it. So that means, as per the Constitution, the President is a nominal executive. He has to act in accordance with the aid and advice of the Council of Ministers, but he is also having one option. What is that? Whatever the advice that is given to him, he can send it once for the reconsideration again for the Council of Ministers. But if the Council of Ministers again send it back, then he has to act in accordance with such advice. So that is what the 44th Constitutional Amendment Act. So the 44th Constitutional Amendment Act is giving the President to send any advice for what is called as reconsideration. So this is the constitutional position of the President in our country. So does it mean that the President under the Constitution has no discretionary power? Or in other words, does it mean that the President should always act in accordance with the aid and advice of the Council of Ministers? This is the question that I wanted to ask after explaining the constitutional provisions. So you should have a understanding of what is Article 52, what is Article 53, what is Article 74, what is the 42nd Constitutional Amendment Act, what is 44th Constitutional Amendment Act. After all these things, does it mean that the President should always act in strict accordance with the aid and advice of the Council of Ministers? Yes, in most of the cases, the President is bound by the aid and advice of the Council of Ministers, no doubt. But it doesn't mean that the President has no discretionary power. So what is the constitutional position of the President? Yes, of course, he is a nominal executive. But can we equate the President of India to what is called as a mere rubber stamp? A rubber stamp means it cannot think on its own. So that is basically what is called as a rubber stamp. While nominal executive means, yes, he has to act in aid and advice of the Council of Ministers, but can that be equated to mere rubber stamp? Thus, the President of India is a mere rubber stamp? The answer would not be right thing. So to call the President of India mere rubber stamp is not the right thing, because that is not the role that was envisaged by the Constituent Assembly to the President of India. Though the President is a nominal executive who has to act in accordance with the aid and advice of the Council of Ministers, but despite all those things, the President under the Constitution is also given certain discretion. So discretion means where he can act on his own. And I would classify that this discretion as what is called as constitutional discretion and what is called as situational discretion. That means constitutionally he exercises certain discretion, and under certain situation, that means situation means it is not explicitly there in the constitution, but when a situation arises, under such a situation he can exercise that discretionary power. That's basically what is called as situational discretion. So constitutional discretion means by virtue of that is mentioned in the constitution, he is exercising that discretionary power. When I said discretionary power, he doesn't have to act in accordance with the aid and advice of the Council of Ministers, and that's basically what is called as situational. That is basically what is called as discretionary power. So I'm just repeating it again. One is constitutional discretion, another is what is called as situational discretion. So constitutional discretion means by virtue of being mentioned in the constitution, he is exercising that power. Situational discretion means that he is exercising upon a particular situation, he will be able to exercise that particular power. So if you have to understand the constitutional position of president in India, no doubt he is a nominal executive, but he is not considered to be a rubber stamp. It is because of the fact that under the constitution, he can exercise certain constitutional discretion, and then upon certain situations, he can also exercise certain situational discretion. Say for example, whenever an advice is sent by the Council of Ministers to the President, and if the President is not happy with such advice, he can send that once again for the reconsideration. Although not many President has exercised this, but there are President who has exercised this constitutional discretion. Say for example, Dr. APJ Abdul Kalam, when he was a President of India, when one bill was sent to him, Office of Profit Bill, when that was sent for the president for his assent, he was not happy with that particular bill, so he has sent it once for reconsideration. And then again, the Council of Ministers sent it, so probably then he gave the approval. So similarly, there were other presidents also who has exercised various advice that was given by the Council of Ministers for reconsideration. So that means that is constitutionally allowed for the president to do that. So that is basically a constitutional discretion. But the president can also exercise what is called as a situational discretion. Under certain situation, when the situation arises, then he can exercise his discretionary power, and that's basically what is called as situational discretion. Say for example, when the Council of Ministers, when they lose the majority in the parliament, because under the parliamentary system, one of the essential things is whenever the government is formed, that government should always have a majority in the Lok Sabha. That's a precondition for the legitimacy of the government. So whenever the government is formed, or the Council of Ministers should always have a majority in the Lok Sabha, not only at the time of forming the government, for the rest of the term, they should always have a majority. At any point of time, there is a no confidence motion or the government loses the majority, then this particular government can be dismissed by the president. And that's a discretion of the president. The government can dismiss the Council of Ministers the moment they lose the majority. So under such a situation, he can do that. Otherwise, he cannot do that. And when the government has lost the majority, then the advice that is given by that Council of Ministers is not binding upon the president. Because at that point of time, the government becomes what is called as a caretaker government. So in reality, the president actually does not dismiss the government. But what happens is the government becomes what is called as a caretaker government. And what is this caretaker government? I'll explain that a little later. So right now, try to understand. If the government loses the majority, that is the Prime Minister and the Council of Ministers loses majority in the Lok Sabha by a no confidence motion, then that government will be called as a caretaker government, and they will continue to be the Prime Minister and the Council of Ministers till the new government is elected after the elections. But the situation is the advice that is given by the caretaker government is not binding upon the president on a major policy issues. So the president doesn't have to act in accordance with the aid and advice of the Council of Ministers, but this he can exercise only under such a situation. Unless and until the situation arises, he cannot exercise his power. Now the next example that I can give is, say let us assume that the Prime Minister, when he is in office, suddenly dies. He or she suddenly dies. And then who is to be appointed as a Prime Minister is normally the conventional practices. If the party where the Prime Minister was there and who suddenly dies, the party has to elect a new leader. And when they elect a new leader, usually that person is appointed as a prime minister. But when there's no obvious leader and the party has no choice, then it is a discretion of the president to appoint the prime minister. Say, for example, after the death of Prime Minister Indira Gandhi, then there was no obvious successor in the party. So every minister tried to become the prime minister and there was no consensus. And then the president of India, President Gyani Zail Singh, he appointed Mr. Rajiv Gandhi as the prime minister, although Mr. Rajiv Gandhi was not even a minister at that point of time. So that was basically a situational discretion of the president as to how the president has exercised his discretion. So this is basically what you'll have to understand. So what you'll have to understand with regard to the constitutional position of the president in our country. If you see the constitutional position of president in our country, he is definitely a nominal executive, there is no doubt. But however, to equate the president of India to a rubber stamp is not true. It's because of the fact that the president can exercise certain constitutional as well as situational discretion. Constitutional discretion means that these are all discretionary powers given in the constitution itself explicitly. But whereas situational discretion, it is not mentioned anywhere in the constitution, but when a situation arises, under such a situation, he can exercise these powers. And that's basically what is called a situational discretion. But otherwise, if you look at the design by virtue of Article 52, Article 53 and Article 74, there is no doubt the President of India is a nominal executive. And that is what you will have to understand with regard to the constitutional position of President in our country. I am sure that it is quite clear to all of you. So we'll have to make it very clear as to what is the constitutional position of president in our country. So why I am saying this? Henceforth, when I use the word that the president is the one who is supposed to exercise his power, it is not the president, but based on the aid and advice of the Council of Ministers, because the president under the Constitution of India is merely a nominal executive and he is not a real executive. But whereas who is a real executive? It is a prime minister and the Council of Ministers, because in India we have what is called as a parliamentary democracy. And in a parliamentary democracy, anyone who forms the government should have the support of the people. And that is why the people elect their representatives, send them to the Lok Sabha, and from the Lok Sabha, whoever is having the majority, they form the government. And this government would be, which is headed by the Prime Minister and the Council of Ministers, they would advise the President, and the actions of the government will be taken in the name of the President. But otherwise, the President is merely a nominal executive. So sometimes students do ask me that in that particular case, why do we need a President? We don't even need a President if the President is to be nominal executive. There could be just Prime Minister and the Council of Ministers. But however, the Constituent Assembly wanted someone to be head of the state who does not belong or who does not represent a party. Because the Prime Minister and the Council of Ministers, despite the fact that they are the Prime Minister and the Council of Ministers, they form the government, but they do represent a particular party. They may represent a particular ideology, but that is not the case with the President. The President is someone who is beyond party politics. And above all, the Prime Minister and the Council of Ministers need someone to use his discretionary powers whenever it is required, so that the Constitution is provided for what is called as the office of the President. So this is the basic understanding, but however, the President under the Constitution of India is merely what is called as a nominal executive. So this is the basic understanding you should have with regard to the constitutional position of the President. So I'm sure that the constitutional position of President is very clear to all of you. So I will discuss more about the President of India in the next lecture. So in this lecture, I'll discuss only this because it's conceptually a very important area. So in the next lecture, I'll take about the qualifications to become the President of India and the conditions of the office of the President of India. So all those things I'll take it up in the next lecture. So if you have any questions related to this particular lecture, you can reach out to me through my Instagram account or through my Telegram channel, which is Babu_IAS_337. And not only related to this particular lecture, but any of the other doubts related to the exam also, you can reach out to me. If you like this video, you can refer it to your friends and family members who are preparing for UPSC examination. And I'm quite sure that this will be immensely beneficial for the students preparing for the competitive examinations. Thank you very much. Keep watching. All the best.